We are ready to start panel 5, addressing how can national jurisdictions strengthen their cross-border cooperation in international crimes cases, exploiting opportunities offered by new sources of evidence and innovative cooperation tools. And our moderator today is our co-organizer, Matevz Pezdirc, from the Genocide Network Secretariat with Eurojust. So I will hand this over to Matevz, and we look forward to an interesting discussion. Thank you.
Many thanks, Jennifer, for your kind introduction, and of course for keeping us exactly very punctual on the program. It's a great honor to be here, and again, many thanks to the Academy for hosting this event and for partnering with us on this important discussion and conference. So the panel that I'm moderating will address the aspects of national jurisdictions in a way of their cross-border cooperation, and basically what are opportunities, novelties, innovative cooperation tools to obtain evidence, but of course to progress cases and to be more effective. As a way of introduction to this panel, I think we can all acknowledge that until the last decade, the usual concept of either universal jurisdiction cases was that first the conflict had to end it, and then you had basically looking into potential perpetrators in your country, and then assessed how to cooperate with the country where the crimes have been committed. We saw that from Rwandan context, from ex-Yugoslavia conflict, in Sierra Leone, DRC, Kosovo, Liberia. It was always the pattern that the conflict ended, and then the cases could start in that respect. First with investigations, sending, even if the cases were done in relation to universal jurisdiction, you've sent your investigative team on the ground in that country to collect evidence. However, the last decade offered a different approach, quite with innovative and I think creative approach in that respect. We had actually investigations that started being done completely, and then also with indictments and trials being conducted with verdicts while the conflict was still ongoing. And we saw that in many cases in relation to the conflict in Syria. We see that with the situation in Belarus, there's ongoing investigation. We see that also in relation now to Ukraine, that there is still an ongoing conflict, and we're seeing investigations being done. So in that respect, we do have sort of remote investigations and prosecutions that are based on either universal jurisdiction principle or nationality principle, where the national of your country is involved in those crimes, either as a victim or a witness or as a perpetrator. We had in this relation, for example, the first case in Syria already back in 2016, where the Swedish court convicted a person that was found on a Swedish territory for torture and as a war crime. And basically they had to establish that there was a non-international armed conflict at the time of the incident. And of course this was done completely with no access to the territory, but using open source information and other assistance from partners. So in that way, I think our panel will offer possibility to look into these novel approaches of use of open source information, use of mechanisms that have been set up in the last years, like UN mechanism for Syria, UN mechanism for Iraq for the crimes of Daesh, and of course the important role of civil society community, of NGOs that have contributed to gathering of this evidence and information and brought that to national authorities. So the panel will discuss these really operational aspects, but also what are the new legal tools, what will be offered in the future to practitioners to have more efficient cooperation when they need to conduct prosecutions in that respect. So we will hear how UNITAD supports national authorities. We will hear how efforts of Commission of for CIJA effort fill the gap in gathering of evidence, and how discussions on a new legal framework will enable countries to be more effective in judicial cooperation. So our first speaker is Christian Ritscher, currently holding position of a special advisor and head of the United Nations investigative team to promote accountability for crimes committed by Daesh, or in short, UNITAD. Christian is a long-standing member of the Genocide Network, and I'm very happy to have you, Christian, here today in the panel. So before your position as a special advisor and head of UNITAD, you were head of the German war crime team at the level of the German Federal Public Prosecutor General. In that function, I think you were instrumental in building support and engagement of German prosecution office to deal with these crimes. Personally, you were involved in the case of Ignaz M. and Straton M. In that respect, and I think it's an absolute delight to hear from you. The floor is yours.
Thank you, Matevz. Thank you to the organizers of this conference, to the Academy and the network for inviting me and tell something about UNITAD and UNITAD's work, and particularly in regard of the topic of this panel. It would have been interesting to participate in the last panel as well, because, as you know, according to the mandate of UNITAD, Iraq is the primary intended recipient of the products of UNITAD, and so in a way we are a supporting team for national jurisdiction in dealing with their own cases in their country. Nevertheless, let me tell you something about this topic of this panel: how can national jurisdiction strengthen their cross-border cooperation in international crimes cases? Regarding this leading question of this panel, a lot was already said during the last 2 days. Nevertheless, I'd like to add some more remarks from my point of view, and please apologize if you get the feeling that I'm telling something what you've already heard during this conference. As international crimes, due to their nature, literally always have an international component, and generally not only concern one country but humankind in itself, the judicial answer must be, that's at least what I'm convinced of, must be international as well. So cross-border cooperation of the national investigative and prosecutorial entities is key to a successful fight against impunity. This is my experience from my work as a German prosecutor. This has to be done in order to combine a pool of forces and to avoid parallel work of competent war crimes units. In the end, there is a place, I'm convinced, for everyone in the House of holding perpetrators accountable. National jurisdictions, international entities like the ICC, the UN and hybrid tribunals, the UN investigative bodies like IIIM, IIMM or UNITAD, or the Commission of Inquiry or the groups of experts, the continental entities like the Kosovo Specialist Chambers, and of course the civil society organizations, the NGOs. But as such an amount of players is going to be complicated, there must be coordination and cooperation between the bodies I just mentioned. This is more and more organized now, as we can see here even in this conference, and a lot of effort is currently put into cooperation and coordination. To name one example I'm quite familiar with, and it was mentioned several times during this conference, the Genocide Network meeting of Eurojust is surely the most successful network for investigation and prosecution of international crimes in the world. It consists of European and associated like-minded countries' representatives, but can and should be a role model for other regions in the world as well. This was discussed yesterday, and I fully agree with this. UNITAD is proud to participate in this institution. This enables us to deliver the results of our work easily and without a bureaucratic effort wherever it is needed. This being said, please let me elaborate on my visions of cooperation and coordination. Clearly, United Nations entities such as UNITAD definitely embody more than just a repository of evidence. It goes beyond this, as it is a hub centralizing expertise that some national jurisdictions do not necessarily possess, such as top DNA laboratories on the leading edge forensic technologies and capacities. And this hub can be placed at the disposal of different variety of judicial institutions taking over towards the trial phase, such as national jurisdictions, of course, ad hoc or hybrid potential tribunals, or the International Criminal Court. This type of hub, when directly located in one of the countries of reference for the mandate it geographically encompasses, like UNITAD in Iraq, reduces the distance towards accessing the evidence. It also promotes a regional outreach and approach of the fight against impunity. Such a hub inside the respective country would enable direct contact with representatives and with the judicial requirements of this country as well. This is what we have established in Iraq. UNITAD is in the country. We have 3 offices in Baghdad, in Duhok, and in Erbil, where the investigators are located, and we are in a very direct contact with our counterparts of the Iraqi security forces, and particularly with the Iraqi judiciary, in order to identify the evidence, to collect the evidence, to preserve and store the evidence, which is needed for the case briefs of UNITAD, which can be needed for the trials and the investigative work in Western countries, in Europe and North America and elsewhere in the world, whoever might be interested, and of course within Iraq, where it is needed. This type of hub, as I mentioned, can be the primary responder for requests for information or assistance, as it is the natural holder of a large part of evidence and as an interface with national judicial authorities. Based upon cooperation agreements or exchanges of letters, this legal cooperation net and framework between third states and the UN entity is one key and innovative forum to share data and information on crimes and perpetrators according to each other legal conditions. So this is something very particular when it comes to UNITAD. If you want to get some evidence from UNITAD as a national prosecution service, you don't have to go through OLA in the headquarters of United Nations in New York. You can directly contact UNITAD because this is in the mandate to promote accountability even in third states, in member states. From my current position on and thinking of the past, I can certainly praise the legal cooperation framework between national jurisdictions and UN independent mechanism or investigative team. To go on with this issue, national jurisdictions can further strengthen their cooperation while exploiting opportunities offered by new sources of evidence. That is at least in your folder part of today's topic. When investigating core international crimes, massive violations of human rights and international humanitarian law, we all know that the collection and preservation of evidence of these crimes committed on a large-scale basis, sometimes in remote places and quite a time ago, represents one core challenge. The variety of evidence as well as the quantity that needs to be gathered, stocked and analyzed remains extremely unique in comparison with other types of investigations. Certainly, harnessing this type of evidence with the help of modern technology can be pivotal to gain efficiency, accuracy, and fostering a proactive, time-saving screening of this data. Coming back to the topic of our roundtable this afternoon, when one investigative entity or judicial mechanism created by the international community, such as UNITAD, for instance, possesses these types of advanced technology tools, like, for example, software digitization capacities, DNA laboratories, excavation experience, and exhumation equipment and know-how, this certainly helps cross-border investigations for national judicial authorities which do not have such resources. Through requests for assistance or information, the United Nations investigative teams or mechanisms can fill a great gap here and share the burden of evidence gathering with different national prosecutorial authorities. This is what UNITAD is designed for. Yeah, so I can only say, please make use of that. On the other hand, national jurisdictions can also strengthen their cooperation while exploiting innovative cooperation tools. Well, let me take the opportunity to expand here on the JIT framework. It was mentioned already yesterday, the Joint Investigation Team Forum between 2 or more national judicial authorities. This framework of investigation based on a legal agreement proposed at Eurojust level is becoming more and more utilized as the adequate structure between competent authorities of 2 or more states for the purpose of carrying out international criminal investigations. The recent innovation in this regard maybe is that mechanisms and entities from the United Nations or international community may be participants to this type of JIT and support national judicial authorities in their cross-border cooperation efforts. As you may know, UNITAD has been proposing its support in that framework from the onset of the creation of the JIT by Sweden and France on ISIL crimes committed against the Yazidi community. When I was head of the War Crimes Unit S4 in Germany, we had a JIT together with France. Later on, Sweden was participating as well regarding crimes committed by the Syrian regime. This was only between these 3 national entities, whereas the one I'm just referring to between Sweden and France on ISIL crimes, we have some innovative approach because UNITAD is currently providing JIT members for the purpose of their structural investigations with the establishment of dedicated evidence analysis and search facility with a collection of additional testimonial and forensic evidence through field-based activities in Iraq and, of course, with community engagement and outreach. So this type of innovative configuration of a JIT composed by members and supported by a United Nations entity as a participant can definitely open new successful doors of cooperation between prosecutors from different countries investigating core international crimes. And you can see that in a way as well in the new JIT regarding Ukraine, where the ICC is going to participate or is already participating. Yeah, that is outside the EU, of course, and that's the new approach. Finally, allow me to also mention one last aspect of an enhanced cooperation between national jurisdictions dealing with core international crimes. As a prosecutor, I would be more likely oriented to be thinking exclusively on the investigation phase, but I'm convinced that it is also necessary to encompass, in my answer to this panel topic, the trial phase per se. Indeed, the trial phase shall not be left over as this is also crucial timing within the whole accountability process of core international crimes. And in fact, during this phase 2, national judicial authorities, when organizing core international crimes-related trials, may gain in resorting to a cooperation via international bodies and mechanisms set up by the international community. Especially during the hearing phase, allowing a video conference link with witnesses sitting at secure facilities in the region of the crime scene, having international experts on forensic anthology or technology testifying before the court, precisely working in the region of the crime, can certainly be of critical importance to convince the judges. Let's not forget that these services and cooperation tools can be provided by United Nations entities mandated for that. Well, these are the few thoughts I wanted to share with you now. Maybe we can elaborate a little bit more on the questions. When elaborating on an enhanced and pioneering cooperation between national jurisdictions while addressing core international crimes. Thank you.
Many thanks, Christian. In my work, I think I often engage with national authorities who praise the work of UNITAD and the assistance there. And I particularly liked your offer for all the national authorities to direct contact UNITAD for any assistance, and I like your vast menu, to put it that way, from DNA laboratory and technical assistance to also support during trial phase, forensic anthropologists, secure room for witness, and so on, and to really be this offer to share the burden of evidence gathering. I think that is super important to take into account for any national prosecutor dealing with the cases of Daesh in that respect. And that will lead me, of course, then to our next speaker, Dr. William Wiley, founder and executive director of the Commission of International Justice and Accountability. Bill, as an old friend, has over 20 years of experience as practitioner in the field of international criminal and humanitarian law. He worked in War Crimes section of Canada Department of Justice, then in offices of the prosecutor of the ICTR, ICTY, and also the ICC. He also worked at the UN Assistant Mission for Iraq, and then in 2012 founded the Commission for International Justice and Accountability, and a great honor to have you here in the panel.
Well, thanks, old pal. It's a real pleasure to be here. When Matevz rang me, I guess quite some weeks or 2-3 months ago, to say that this panel or this conference was put together and asked if I would come, I don't tend to do a lot of engagements like this for various reasons, although I must say I've enjoyed myself immensely. But Matevz said, come on, we're buddies, we'll have a few beers and so forth. And it doesn't take much to encourage me. But he also pointed out that this would be our old friend Klaus's final act. And I had the privilege of first working with Klaus at the start of his international career, back in at the ICC back in 2002, 2003, something like that. And I said to Matevz, right, we're finally going to see the back of that bastard, and I'm not going to miss that. No, in all seriousness, I didn't want to miss it because Klaus has been a wonderful colleague, and I certainly regard him as a friend. He's the best of an international public servant, loads of institutional loyalty, get stuff done attitude, and buckets of moral courage. And as a minimum, he's always good for a cigarette, a beer, and a laugh. And you'll be missed, old boy. You really will. Thank you. Right, I meant to say something else apparently. I've put together a few disconnected thoughts. I celebrated this past March, a few weeks ago, the 25th, my 25th anniversary in the war crimes field, in the field of international criminal law. It was a Tuesday, so of course I got drunk, and no, I didn't. But it was certainly a time for some reflection. And in fact, the last few years, I've had the opportunity, because I've had the privilege of being in charge of CJA for quite some time now, to think more and more about our field of law, obviously how to make it better, where it's going in the future, and so forth, relying obviously on my experience, such as it is, and also my academic education that was focused on the evolution of the law of armed conflict. And that dissertation was finished just at the point that the Yugoslavia Tribunal was being operationalized. I thought I was an Army officer at the time, and I thought I'd have a career in the Army. It's a bloody good thing that the ICTY was set up. Good for me and good for the Canadian Forces. So, what is the future? So I don't propose to talk all that much about CJA. Most of you know about it. I want to throw some ideas, some broader ideas out there for discussion. This is a very well-crafted conference because there's loads and loads of time for discussion, which I appreciate very much. The short answer in terms of the question posed by the conference as a whole, it's my considered view that the future of international criminal justice is domestic. It is not international. So it's the application through domestic courts and tribunals or national law enforcement, the application of ICHL by those means, with some mixes and matches that I'll come to in a moment. So we have the national jurisdictions that we're all familiar with. We've been very fortunate to have some colleagues speak about their experiences in that regard. Thanks not least to Matevz and the Genocide Network and indeed Eurojust, I find these JITs that are coming together in our field to be very exciting and filled with tremendous potential for the future. And then the chair of my board, people think I don't have a boss. De jure I do. De facto perhaps not so much, but Ambassador Rapp, chair of the CIJA board, obviously is very busy still on the political diplomatic front in trying to get international justice mechanisms established, but effectively through domestic arrangements, building on JITs or pooled jurisdiction. So whether pooled jurisdiction is an international approach or effectively, let's call it a joint domestic approach, I believe this is the future. I don't want to suggest that I've given up on international courts and tribunals. In some respects, we only have the one left, the ICC, of course. You know, that's, I think, another conference is what's gone right and what's gone wrong, at least with international OTPs over the last 29 years now. A lot has gone right, but a lot has gone wrong. And I was thinking prior to coming down here why things have not gone right. And of course, inappropriate people in certain positions and you know, hiring practices, but I don't want to talk about that. And I don't want to dwell on this issue as a whole all that much. I think the fundamental problem is, it comes down to a question is who owns the law? In this case, ICHL. There's a political scientist in Australia named Melinda Rankin. We've got some academics writing papers about CIJA now. We're always happy to support that, irrespective of what they ultimately think of CIJA. Melinda's unusual. She comes at this from the perspective of a political scientist. All the rest are legal academics. And as a political scientist, she's interested in this question of who owns the law. And I would suggest, and I don't mean to be provocative here, it's just an idea I throw out there, I would suggest that states own the international institutions. They most certainly own the ICC. It's a treaty body. It's very simple. So you end up with a sort of metaphorical democratic deficit of the sort that's lobbed, for example, at the European Union or certain of the EU institutions. It's well removed, say, from the constituency. And yes, there's vernacular about, well, victims de jure own these institutions and so forth, but I don't think the people running those institutions, and certainly the states that fund them, truly believe that. And I say that with no malice. I just think that is the case. The domestic institutions are very old. The procedural laws and so forth, they're very well established. And it seems to work to layer a new field, in many respects, a new field of law, to incorporate it into the domestic penal codes, it's working. It's working. And again, the international courts are too expensive in the views of the states paying for them, too slow again, in the views of others. I don't necessarily agree with this calculus, but that's where we are. So whatever the future is, domestic or not, so let us park that idea. The future, whether it's domestic, as I think, or domestic and international, as others would posit quite reasonably, I think whatever the case, the future is going to be and needs to be based on public-private partnership. So the public sector institutions, again, be they domestic or international, with support from the private sector. Now, private sector, what I mean by that is the non-public sector. I think in terms of the non-profit sector, foundations, NGOs, what have you. But in principle, there's no reason why commercial companies could not be engaged in international criminal investigations in support of public authority. But it's probably, again, my prejudice, it's more appropriate to do this in a not-for-profit way. And the CIJA was set up precisely to test this idea. I had set out this idea with Morten Bergsmo, another old colleague and friend in intellectual crime, in a scholarly paper that we published probably around 2009. And when the Syria war kicked off and the Brits approached us about doing some human rights work, and I said, no, I'm not a human rights guy, I'm a criminal law guy, and they said, that's fine, do that, do anything. I thought this was an opportunity to test the very, at that time, basic theories that Morten and I had set out in this book chapter. And it has worked. It's worked. It's 10, 11 years now. It has worked. The mission of CIJA, but it's not about CIJA. The mission of the private sector, in my view, where it wants to engage, is to extend the criminal investigative reach of the public sector into areas that it cannot penetrate itself. It's a very simple idea. And the public sector can't get in there for political diplomatic reasons, oftentimes. So Judge Marchiuel's mechanism is not welcome on Syrian territory. It's a UN body. She can't go, or she can't send her people. And for reasons of physical risk, even if Damascus invited the mechanism in and said you can have your people running around, it's too dangerous, these types of environments, for public sector officials. Public sector institutions, not the individuals may like to do it, but for the institutions, it's for various very good reasons, some of these places are too dangerous. So with CIJA, as everyone knows, we've operated in Syria, as I said, since 2011. Ambassador Rapp mentioned yesterday our operations vis-a-vis the regime. At this point, we hold 1.3 million pages, original pages of Syrian regime material, and all kinds of other stuff. We operate in Libya. Mostly we're basically finished in Libya now that UNITAD is up and running. Mercifully, UNITAD is based in, Iraq, thank you, is based in Iraq. So you don't need CIJA in Iraq anymore. We have some residual special operations there that are again in support of the public sector, but different than what we were doing before. Our Burma operations just concluded at the end of April after several years. Again, designed to support the public sector. That was an unusual case for CIJA where we operated covertly in Burma, within and around the perpetrating structures. Security forces of Myanmar to collect linkage evidence, or prima facie linkage evidence. And we also operate in Libya, and are, now that COVID is done, are starting to build up those operations, which are now 2 years old. They're actually focused on human smuggling, human trafficking, principally from West Africa through Libya into Europe. So the reason I don't want to talk so much about CIJA is because see it as there's more or less a consensus that the CEJA model works. What I want to see is the CEJA model applied by other NGOs or other private sector institutions, because there's more than enough war to go around, and the public sector needs that much more assistance. What's the downside? And I'm going to wrap up in a couple of minutes. What is the downside with this private model? Well, I don't know, accountability, if you will. Now, that's more imagined than real. CEJA is funded by a myriad Western states. If we were a bunch of undisciplined or incompetent cowboys, you know, the money's cut off. That's the best kind of control ever. Tell me a public body that's subject to that kind of constraint, and particularly an international one. I haven't seen it yet. So. But we've been working with Klaus and his team for about 3 years now. In fact, we'd have been done some time ago, but for all this COVID nonsense, or the response to COVID. We have draft guidelines to govern the conduct of private international criminal investigative bodies. And those drafts have actually been shared with a fair few interlocutors, public and NGO, for comment. We just haven't got over the final hump to launch the thing. But hopefully your successor will be keen on that, and I'm sure she or he will be. So right now we have a situation where, with rare exceptions, such as Bellingcat, Berkeley Human Rights Law Center, that have a specific open source or OSCENT focus, Mazen Darwish's group in Paris with a particularly Syria focus, obviously, and some others, but you don't have still much private sector support to the public sector. What we've seen, it's a point that Anya made yesterday, what we see is a lot of NGOs using the vernacular of provision of support to criminal investigations, but it's, I mustn't use profanity because I appreciate there's children watching at home at this moment, but it is much more vernacular than real. And the program officers who dish out the money do not understand that. So there's quite a ways to go there, but that's ultimately what my mission, first and foremost, is to continue pushing for that. Thank you.
Thank you very much, Bill, for this insight into the rationale of how CEJA was set up, and also the throwing out the idea to the discussion later on public-private partnership or public-non-profit partnership, and of course raising the issue of a dangerous environment in which you operate, or of course in which war crimes against humanity occur. And the risks for public institutions, or the non-tolerance to the risk for public institutions in that respect. But I think the most important takeaway from your intervention was that best ideas and best cooperation is made over a few beers. I think that's for sure. But I think also you touched upon the issue of who owns the law, and basically responding that states own the law. And I think that brings us to the next speaker, a diplomat among us, who will of course explain whether states do own the law and how states plan to create a new law, to develop a new law. So the next speaker is Dr. Marko Rakovec, Director General at the Ministry of Foreign Affairs in Slovenia, and he's also a dear friend of mine, and very happy to have you here, Marko. But before becoming Director General on this position, he served as in the Human Rights Department of the Ministry of Foreign Affairs. Prior to that, he was a Deputy Ambassador to Croatia, and worked as a legal advisor at the permanent mission of Slovenia to the UN in New York. So I think a wealth of knowledge and experience. And Marko, happy to hear from you.
Thank you very much, Matevz, and I'm really honored to be invited to this outstanding conference. Of course, the offer of beer helped as well. Well, not very diplomatically, but we have Chatham House rules. Really, for me as a diplomat, it was really a privilege to listen to you practitioners and the scholars. And really, I would like to commend Klaus and his team for setting up really such amazing number of prominent speakers that really explain the details of several processes, something that we cannot otherwise listen or read. So it was really the best conference I attended in my, I think, 20 years. This is so important for us diplomats because, of course, when we negotiate new instruments, we have to understand what are the needs. So if we don't understand the needs, then we end up with certain invalid instruments. And I think many of you already explained during these few days several diplomatic efforts that were not really in the right direction. For Slovenia, for Slovenian diplomats, it was always international criminal justice in the forefront of our foreign policy, being one of the republics of the former Yugoslavia and witnessing atrocities in the 90s. So we always attached great importance to this, and is also now in our foreign policy strategy one of the core priorities. And well, as a small state, we would still like to contribute as much as we can, and I think we did. If we look back, 20 years ago, still today we have a much better system. Of course, there is still a lot to improve, but well, if we look back, with establishing international tribunals for Yugoslavia, Rwanda, the jurisprudence that is so much relevant for the International Criminal Court, but also for now domestic procedures, it really, we are much better off than we were. Well, the whole conference focused on domestic proceedings, and we can see, and particularly in the previous panel, what different models are at our disposal, and what works, what doesn't, and maybe, we don't have one size-fits-all shoe model, so it's really we have to plan according to the situation. But still, I think we have a general idea what works, and what is always needed is the political will. This was discussed previous panel, it was discussed before, and without that we cannot end up with any good result. And here again we come here to foreign policy, where we have to create this effort. It is for us, the diplomats, to convey to our political leaders that it is of paramount importance to address impunity. And today I think we are at the stage where this is more or less understandable. It was not 20 years ago. We were discussing, extraterritorial jurisdiction, even universal jurisdiction. What we were reading articles, this is the judicial tyranny of international relations, and it was not speaking about. So this is, I think, really a huge progress. But what is missing, and what was actually I wanted to speak about. The new legal framework, that additional possibility that would facilitate all domestic judiciaries with better being equipped to prosecute these crimes. Because now what we can see is that the states with relatively huge resources that can efficiently exercise those cases, like it was explained by Dusha, Germany, Sweden, Netherlands. But it's not all the states that we would be at the same stage, So what can we do that we would bring these cases as close to the normal cases when we have, murder, territorial jurisdiction, and, the process normally proceeds. And here, we need cooperation. It's something that it's for war crimes, crimes against humanity, genocide, or for international crimes. It's a cooperation of several states, and usually, these mechanisms are not efficient enough. They depend on bilateral agreements or even ad hoc agreements, and then really depend on the other side whether they will respond to the certain request for judicial cooperation or not. And in many cases, this does not happen. So proposal is that we would have a multilateral treaty that would enable all states to cooperate efficiently. So international treaty for cooperation on investigation and prosecution, as well as tradition, when prosecuting international crimes, in particular war crimes, crimes against humanity, and genocide. This project is now going on already for 10 years. So it's together of a couple of states. It's the Netherlands, Belgium, Argentina, Senegal, Mongolia, and Slovenia. So 10 years ago, we started, discussing, but particularly to the practitioners, explaining what are the main challenges. And according to that, we said, okay, so how can we help? And we engaged in discussion, and now we have already quite extensive draft of 71 articles that was supposed already to be negotiated at the diplomatic conference in Slovenia in 2020. Unfortunately, it had to be postponed because of COVID. But now, next year, exactly in 1 year time, next May, we will convene a diplomatic conference. And, well, we really hope that many of you will contribute to this effort. We have 80 states that expressed support for the instrument. Well, we think this is quite a substantial number of states that might also then, of course, negotiate and then sign and hopefully also ratify the new treaty that would provide, I think, much better basis for prosecuting these cases. All the information you can find on the special web page that is designed for that. There are going to be also virtual consultations in June, on the 1st and 2nd of June. So many of you might have received already invitation. Otherwise, let us know. We will send you invitation because we would really like you to contribute, and that we would have the draft of the convention as close as possible to be then negotiated in that on the conference in Ljubljana. So I think, part of that, we have also some other maybe ideas how we can improve the situation many times, and this was discussed, it was raised by Klaus and also by Matevz, the financing part. For sure, at the moment, when the system depends, I think, on the devoted, extraordinarily devoted individuals, like he's in a Haber case, like Riti, and then being marked even as a crazy man. But, without those dedicated persons that many of you are in this room today, these processes wouldn't happen. The idea is that we would come to the new structure, that we would have these cases as normal as possible. So, that you would have normal procedure without any political interference, and you would be able to proceed. At least, for the lower level cases and middle level cases, of course, for high level cases, it is very difficult because it's so much political influence and international relations. But this is why we created international tribunals. So this is the international tribunals to deal with those. But the rest, we should pursue, and what many of you are doing, to be tried at domestic level. And as I said, for us diplomats is to help create this atmosphere, the legal framework and all the tools available for that. I will stop here. Thank you very much.
Thank you, Marko, and for highlighting the difficult role of a diplomat to basically, own the law, or basically bring the law closer to the practitioner, and of course to understand what exactly is then the need of practitioners to do something that's meaningful and useful on that. And thanks for sharing that also. There's already 80 states supporting the instrument, and that negotiations will start in a year on that. So really appreciate this information. And now I think we have quite a good time for a discussion, and of course happy to take questions. Please.
Thank you, Matevz. I have an observation and a question for Bill. The observation is a possible answer to your question, who owns the law? A bit of a blunt answer, probably. I know, in my opinion, who doesn't own it, or shouldn't, and those are lawyers. Too often I come across lawyers that are disconnected to real life, and they somehow forgot the notion that the work that they should be doing and the function of law is like the oil to the society rather than the sand that they make it. But who owns it, that's still open for other debate, but this is my observation. The question to you, Bill, is you mentioned the manual that you're working on and that will be publicized soon. I'm very interested in it. What are your ideas on how to have that put into effect? Putting out a manual with I'm sure very interesting and good lessons learned and what have you, good practices. The NGOs that will pick it up need to be professional. As a prosecutor, I would love to work with NGOs, we do, but only with those that are professional, that are helpful in court, rather than end up causing for incidents and trouble. So besides putting out the manual, do you have any thoughts and ideas on how to reach out to fellow NGOs? Do you do that already? Or is there a debate going, and are you guiding them towards that level that, as a prosecutor, you would like to see? Thank you.
Yeah, thanks for that. First of all, I need to apologize for misleading you and the audience. It's not a manual per se. It's actually guidelines. It's all in the, I don't know, Klaus, 5-6 pages of principles. It's actually a statement of principles. And now, because it's done with Nuremberg, and this is Germany, and it's a legal undertaking, then once that's agreed, then there has to be a commentary on the thing, a whole book, which is going to be great fun, flushing out, giving meaning to the principles in greater detail. But the reason I came up with this idea, I usually have half-baked ideas, which are rubbish, and my colleagues tell me they're rubbish, but occasionally there's one that finds some traction, and then my colleagues will flush it out and give it proper meaning. I'm quite sincere in saying this is generally how it works. But this was my idea at the start, and it's connected to this idea to see more private actors or non-public actors in the criminal investigative space, but there needs to be some control element, But you can't control private organizations. It's not appropriate, it's not possible. But what you can do is you can control their sources of income in a certain way. And so the idea is to, we'll get the principles finalized shortly. They'll be rolled out through Nuremberg. At least this is the concept of ops. We'll have NGOs, we'll have donors, everyone here. And then basically what's going to happen, if all goes according to plan, it'll work, this will work, is when an NGO goes to a donor and says, I want X amount of money to work in place Y to contribute to criminal justice accountability, then the donor can ask the question, right, do you subscribe to these agreed principles, agreed between, let's say, a quorum of public actors and civil societal actors. So that's the purpose. It's because the knock on CJA, or at least the question always put to CJA, at least in the early days, and it is the right question, is who do you answer to? What are your quality control mechanisms? CJA is unique because none of us had ever worked for NGOs before. We absolutely did not know what the hell we were doing. We knew how to do operations in the field because we'd all come from the public sector. We did not know how to raise money. And some of the administrative components we had to figure out. So that's a long answer to your question. I apologize for that, but that's basically the idea.
Thank you. I think we have a next question ready.
Hi, thanks so much for the panel. I'd be interested in hearing more about, maybe from each of you, about whether or not you've confronted any evidentiary barriers or blockages in getting evidence and information that you've gathered through these various means, through the Eurojust network or through UNITAD or through private actors going in country and exfiltrating documents into evidence. Have the judges been relatively open? Have there been challenges by, say, defendants? Just curious about whether or not you've, in the United States, we have very strict evidentiary admissibility rules, and I know that that's not the case elsewhere, so I'd be curious to get just some anecdotal information about how that has gone in cases that have used your materials. Thanks.
Thank you very much. Maybe Christian, you want to start?
Yeah, thank you. Very interesting question. We are considering these potential challenges, of course. Whenever we receive evidence, we always, try and think we can provide that to secure the chain of custody, so that we always can tell in court how we got in possess of this particular piece of evidence, what is the source of it, and how was it stored, and all these things, because we always have to keep in mind that we are delivering pieces of evidence to very different systems of judiciary. Whereas in Germany, for example, of course you have to tell how you got in possess of that piece of evidence, but there's no such thing as an admissibility check. So maybe it is useless, and it doesn't prove anything if you cannot prove the chain of custody, but at least it's not unadmissible unless it is not, didn't get it through torture. That's for sure. But whereas in common law countries, of course, there is an admissibility discussion. As far as I remember, until now, we haven't come across this problem, because I don't remember having, we had in the US, we had a trial which we were supported, but there at that time, there was no problem. I think we delivered some pieces of evidence, and normally in addition, we would provide a person from our team testifying in court and explaining how we got in possess of this particular piece of evidence, the document or the battlefield evidence or something like this. But this is something we really put a lot of effort in, that we can prove how we dealt with this particular piece of evidence, because and it's in the mandate, yeah, to have it up to highest international standards. And, well, I cannot guarantee that we are always successful. Yeah, maybe one day a judge might appear and say, well, that is inadmissible for this or that reason. I think this is unpredictable, but we at least try to be aware of all these procedural regulations so that it can be used, because this is in the end what we stand for, yeah? That the evidence we are collecting can be used in court.
Yeah, it's obviously the key question. Siege is cheaper than a public sector organization, but it's a lot more expensive than a human rights advocacy group. So we've I don't know the precise figure at the minute, but I would suspect that Siege has spent a little bit north of 60 million euros over the last decade of public funds. It's all public funds with CIJA. And if the stuff wasn't admissible, there'd be a pretty serious problem. Now, having said that, the starting point for us when we got the first money to collect acquire documentation inside Syria abandoned by Syrian regime structures. Back in 2012, it was US G money. We had, well, I suppose it was one of the times where CIJA benefited from my being in charge, because I started my war crimes career in the Canadian Justice Department. We were still doing World War II cases at that time. So I spent several months a year running around former Soviet states, principally Russia and Belarus. Obviously going through archives, looking for evidence against individual targets in Canada, but also getting affidavits pursuant to the Canada Evidence Act from the archivists in even Lubyanka prison archive at one point, and in different oblasts. And it was a lot harder than you would think, as an aside, because chief archivist in particularly an old security archive was a job given to security intelligence officers just before they retired. And yet my office wanted the CVs of these guys attached to whatever document we needed with the target's name back in Canada. So there was the drinking was outrageous enough with our colleagues in former Soviet states, and then the additional drinking that needed to be done to convince some KGB officer to give you an affidavit. But institutional loyalty, yeah. Loyalty to the mission first and foremost. So the point is that the real standard, as Christian basically has noted, is not going to be in the the inquisitorial systems. It's going to be in the common law jurisdictions, Canada, US, UK, Australia, and so forth. Our evidence, or CIJA material has gone into evidence in quite a few trials by this point, but the vast majority of those trials are in inquisitorial systems. Germany, obviously, being probably the best example. So that we haven't seen much in the common law. There's only the one case in America, and that was obviously the civil case, the Colvin case, and the Syrian state didn't respond to the I forget the legal term. Anyway, they didn't appear. It was a default judgment in favor of the plaintiffs. But the judge did accept, there was quite a bit of documentation and an expert witness report that went in on behalf of the family, the plaintiffs. So there was no problem there. And then our principal concern, because those running CIJA, we didn't have a lot of experience at the beginning doing counterterrorism or terrorist offense prosecutions, investigations and prosecutions. Investigations were fine, but we weren't sure about the admissibility of some of the material we were collecting, or if there would be problems. And so the US DOJ and the Crown Prosecution Service of England and Wales both very generously, because we had operational relationships with the police in those states, very generously sent some of their lawyers over to our headquarters in Europe to go through our procedures and see if we were doing anything wrong so we wouldn't have a problem down the road when a case was brought. And it was blessed, yeah? Everything was fine. And so we think we're okay. But I'm shocked, particularly in the Koblenz case, we gave to Christian and Christian's office through the federal police some documents, including with the signatures, some documents with the signatures of the principal accused, Colonel Raslan. And I would have expected the defense counsel to at least challenge that, if only for form's sake. And then also we know, some of you know we have problems with the Russians and some of their proxies in the West, particularly in US, UK, and also here in Germany. They're connected with one aspect of Die Linke party. So we did an operation against these people, and as again, some of you are aware. They wrote to the defense lawyers for Al Gharib and Raslan, the two accused in the Koblenz trial, and said, look, the people who are these CIJA guys, Wiley is a CIA officer, and he's, or CIJA, I don't know, me, CIJA, I forget, are financially corrupt and so forth. And to the credit of those counsel, they ignored it. And they wrote twice. I know they wrote twice. Yeah.
Thank you on that. But I can also maybe just to respond to your question. At Eurojust, we actually tried to look on this issue of admissibility of evidence, particularly looking at the battlefield information and how that is transposed into basically evidence. And not only looking at the information that comes from military in the operations, but looking at more largely any piece of information that comes from sort of a battlefield zone of armed conflict. So also what NGOs collect, what UN can collect and share and so on. So that's a public document, a memorandum on battlefield information that you can find on Eurojust website. And we had the second version already, and I'm sure that this will be sort of a continuous process to look exactly at this issue, because I think at the end of the day, it's really the fundamental question how you bring sort of a piece of a paper or information or a sort of other type of evidence from a battleground into a courtroom, how that process works and how different countries perceive differently the issue of admissibility. And it's quite obvious that, of course, common law and civil law countries do have a bit of different view on that. In civil law countries which are more familiar, it's a kind of a complete free evaluation of evidence, and then it's up to judge. Of course, it's not fortified and it's authentic and so on, going through kind of regular forensic process, but then it's up to the judge to give the value of that piece of evidence and the credibility and so on. So very much similar like with witnesses. So, you know, witness can testify as well, give oral statement, and then would be up to a judge to decide what would be the value of that statement in the overall case. And of course that then gives this evaluation in the judgment that can be later on challenged by one or another side. And I think very much same concept is in this respect. But that's I think a good document to look into for this type of questions, and of course something that will surely develop in the future as we will have more and more cases relating to the use of information coming from battlefield zone. Would there be any other maybe comment on the issue of the evidentiary rules and the admissibility? Because I know there are some other prosecutors, but also NGOs in the room. So I'm more than happy to take that. Yes, please.
I will follow up with the previous question, but in specific with the focus on open source evidence and testimonies that are taken from witnesses who are still inside the conflict zone. I would like to hear some answers about the admissibility of such evidence. Just having in mind that all the open source evidence were collected in accordance with international standards, having that in mind.
Who wants to go first?
I think that's a question for Christian.
Christian. I agree.
Yeah, well, I think it's a very good question, particularly regarding open source information. But I think in the end, the answer would be more or less the same. From my point of view, at least, well, of course we gathered a lot of open source information because ISIL had the tendency to publish almost everything, and particularly in promotion videos or whatever you name it, propaganda videos, which of course can be used in court, particularly if you see perpetrators in these videos, what is quite often the case. I want to name particularly in Berlin the trial against where a most important piece of evidence was the video what was produced by ISIL on the occasion of the first anniversary of taking over Mosul, and where the public killing of a police officer of the Iraqi security service is to be seen, and including the two defendants which were participated in this killing. And well, we used that for our case files within UNITAD, and we would provide these videos, of course, if they are needed to member states or to the Iraqi judiciary, whoever wants to have it. And if we are able to, well, in a way to analyze these videos, and well, of course, we are always ready and are able to tell even courts where we got these videos from. Yeah, well, publicly available means that we have probably some from the internet. That's not that. I think this is not a big issue. Even in common law countries, when it comes to witness testimonies, yeah, well. In a way, Iraq is not the conflict zone anymore, so we are in a post-conflict situation in Iraq, and we, of course, do a lot of interviews for our purposes, but even in answering requests for assistance. Well, what we already did, even for the JIT, is to have an interview setting and an interview with a witness, victim witness probably, and investigators and prosecutors from member states are participating through a video link so that they can watch the video while it is done, and then they can interfere if something is going into a direction which might endanger their case or their trial. So that's the way we are doing that in order to avoid admissibility problems with these types of evidence.
Yeah, private bodies and witnesses, there's a lot that can go wrong. First, obviously, you need to know how to interview a witness properly. With an eye to, let's say, elements of offenses, modes of liability that are of interest, and also with an eye to the psychosocial state of your witness. CJA's focus has always been on developing linkage cases as opposed to crime base. And So we have done several thousand witness interviews, but every interview we've done is in the context of some file that we are building connected with Syrian regime, Daesh, and the other institutional targets that Siege has worked vis-a-vis over the years. And the key thing for the private sector is not to take a statement, not to have the witness sign anything. What CJA actually prepares are what we call interview reports, IRs. They're written in the third person. This reflects CJA's, the fact that CJA is led and run by, again, men and women who've come from the public sector. So we have an eye, we know how the stuff, how a case is built. We also know what can go wrong at trial. So our interview reports will go as required or as where they're relevant to Christian. I mean, when he was still at home in Koblenz. In fact, all the Iraq ones have gone to Christian in his, in charge of UNITAD, because we do data dumps to the UN, to Catherine, to Christian. They just get everything. But the stuff's done in the third person, because if it gets into a case file, and then that case file starts to proceed towards trial, in a domestic or indeed an international court, it doesn't matter, then the public authorities are going to want to interview that witness again, you see? And what you don't want, but it's almost inevitable when you interview a witness 2 times, 3 times, 4 times, you're going to get differences between the first, second, third, fourth testimony. Everyone understands that. And so CJA interview reports written in the third person, if there's a gulf between the CJA interview and then the first interview done by a public authority, you can blame it on CJA. You see? You just write it off on CJA. So I used to work that way when I was still in the public sector, particularly at the ICC. I used to do a lot of screening interviews. And I wouldn't take a statement. I'd do all linkage witnesses, do an interview report. Also because it's a bit rushed, it's in the field, different circumstances. And again, the idea is that the interview report that I had done could be dismissed. It'd be a little more tricky, of course, in an ICC, because I was an ICC investigator. But as opposed to when we sat down, we really want this guy, and then we brief him for 1, 2, 3, 4 days in a safe house in Uganda or something like that. So yeah, that's basically what we do.
Many thanks for this inside knowledge. We have another question.
Thank you very much for this fantastic panel, and also to the organizers to having this very important conference for today. I have a question, maybe will sound a bit banal, but how much politics do play a role or have a role in the universal jurisdictional cases? And I want to address this question from 2 perspectives. One, how much the small states, or how the small states may deal with the crimes committed by the big states without bearing in mind this political pressure put on the small states. And the second perspective which I want to raise is the prioritization of the domestic authorities, how the domestic authorities may prioritize. They are dealing with one particular conflict, with one foreign conflict outside, and with the other, they don't put that much attention. What is the prioritization criteria, for example? Thank you very much.
A very strong question on this one for, I think, all 3 panelists. But maybe starting with you, Marko.
Yes, thank you. A very difficult and complex question. Of course, politics play a very strong role, so it was the beginning with universal jurisdiction. We all know so how it was, in the late 90s and early 2000, with the cases, particularly the cases when exercised in absentia, with high-profile persons. There was no possibility for success at all, and it raised very difficult diplomatic relations, negative effects, so it was not the way to go. So I think now the new cases, that focus on the lower, mid-level profile persons, there is certain nexus, not exercising in absentia, all the guarantees for fair process are there at place. It's acceptable. There is no criticism. It can be finalized, and we heard the past few days positive examples on that. Of course, the other question, prioritization, this is definitely a case that we discussed. Every such case needs substantial resources. Of course, if there is already a knowledge and the structure in place, it's not that much resources, and it might be exercised by the small group. But still, at certain phase, you must engage specialized prosecutors, specialized team of investigators, enough financial resources, political support, then you can successfully proceed. And as I said before, if we have these additional mechanisms, maybe I can just, because I didn't tell a lot about the mechanism as such, it's based on the UN Convention on Transnational Organized Crime, mutual legal assistance provisions, also sharing the evidence, sharing the evidence and using them properly would help, I think, quite substantially in that regard. Prioritization of the prosecutor, this is something that I discussed with our prosecutor, that, I can take one of these cases, and then it depends of 10 other cases what I'm going to do. I'm overloaded, I don't have enough personnel, so it's a challenge. So here you need also, I think, wider political or support of the society. And what we can see now with Ukraine, there is definitely a momentum. So there is people demand that those perpetrators would be brought to justice. There is a public discussion. I was just invited to one of the radio stations next week. So it's there. So if people have this discussion, then also I think for the prosecutor would be easier to take this kind of case and justify. Otherwise he would be asked why you chosen that one and you didn't take those, domestic cases. So I think it's the environment that we have we must support and make the case that this is necessary for humanity, for the justice and the peace, reconciliation, and all the trans-border effects, negative effects from other countries or regions that would have certain negative effect also on our society. And then people would understand. Thank you.
Christian, will you want to add something to this? Yeah.
Well, it's a little bit difficult for me as head of a UN entity to answer these questions. Particularly, I can hardly tell anything about small states regarding crimes committed by bigger states. But how much do politics play a role? Yeah, of course, and when it comes to the mandate of UNITA, politics, of course, play a role. On the other hand, well, the fight against ISIL, international crimes committed by ISIL, is well, we had a unanimous decision in the Security Council, and the mandate was, or the resolution was adopted on the initiative of Iraq itself. So we have a political support, so to say. It's of course political, but it's a political support. We don't feel any political pressure against us, and there's no opponent against an investigative team making investigations regarding international crimes committed by ISIL. Priorities of investigation. Well, I can't tell you something about our priorities. The priority is pretty easy. Well, we investigate mostly in the affected communities in Iraq, which is almost everybody in Iraq, because there's no community in Iraq which was not affected by crimes committed by the ISIL fighters. They literally attacked everybody who was against them. Well, of course, they had a particular focus on the Yazidi, on the Shia, on the other religious minorities, but even the Sunni, though ISIL has a Sunni origin, but nevertheless, Sunni people in Iraq was affected as well. This is why we have a particular investigative unit dedicated to the crimes committed by ISIL against the Sunni population in Iraq as well. But we focus or put a lot of resources in the most important attacks of and the most cruel attacks of ISIL, as this is well known that we put a lot of effort in the attacks of ISIL against the Yazidi community, and we will focus on Mosul as the capital of ISIL Daesh during that time. That will be, I think, a big effort in the future, even a bigger than we already. Then it is already in place up to now. But in the end, the priority comes from the investigative necessities, from what is needed. In terms of making an investigation that in the end will have a result showing the full spectrum of crimes committed. The people in Iraq. That's it. So we have. This is a challenge in itself to have that in a quite balanced way. But this is this is the way we are doing it.
I hope that answered your question, or if you have a sub question. But we have also some others on that. Klaus, please.
Yeah, thank you. On politics, the 2018 Nuremberg Forum dedicated to the 20th anniversary of the Rome Statute had the title Law, Justice and Politics. It's all politics. The Rome Statute is politics. There are so many in this room that were active in Kampala for the Kampala Compromise. That's 110% politics. The question for me is, where is it politics and where starts the political influence? And I think this is the dangerous threshold where one has to be careful. The effort that was done to put the Comoros case forward is sheer political intention to bring Israel before a tribunal. And that is a politically motivated activity, and that is where it's dangerous. If for political reasons we would say, oh, that country we are not going to look into, or if there is now put pressure on the prosecutor of the ICC, now you have to go directly against the Taliban, Afghanistan isn't your mandate, go for it. This is a political motivation, and that's where the danger starts. And that's where the prosecutorial policy was always, and rightly so, strictly geared towards the law. It's the gravity of the crime. It's other things, but it's not the political. With the political will and the political well, relations, you find them in the Article 98 agreements, for instance. That's a very political act. But it's not a political influence on an investigation. And this is where I think the line must be drawn, and that this is where one has to be careful. If CJ is sent into a country for a political reason, we want that you find a perpetrator there because it plays into our politics, then it's going to be dangerous. And I think the Lebanon Tribunal was on a very, very thin path in that regard of not being abused by political interests rather than really seeking the truth in order to hold somebody to account for a crime committed. And this is an enormous actually responsibility also for all those who work in environments where this could play a role. Iraq is a great example for that. Other countries where CJ is investigating, it even applies now to Ukraine. Also there, one has to be very careful. Is it about really investigating the truth and bringing perpetrators to justice? Or are we looking for a political argument for or against someone or something? And insofar politics are not the problem, the political intentions, they could be a problem.
This is insulting. Thank you.
It's always hard to speak after Klaus. We can agree on that.
I'll do my best.
For various reasons, of course.
Thank you so much for a very interesting panel. I thought it was really interesting what you were saying, Bill, about how CJ, how you were in Iraq and then how you actually exited Iraq and gave basically Christian the material or sort of you have an exit plan. And I thought this was really interesting because what we can see, and I've seen this in so many years now. I mean, I remember when you came to Sweden before even IIIM and UNITAD existed, and we would turn to CJ because that was our only option. And the way you have delivered evidence, it has a very high standard, and you sort of slowly gained trust among the community in the genocide network. And I think most of the countries I know would work with CJ. But with that said, I think a public authority, as I would represent, would always want to turn to public officials, which something I have seen is that there is a lot of mistrust on different levels, and maybe rightly so, but how do you get NGOs to let go of information, to share to IIIM, to share to UNITAD? And even in the Ukraine situation, I find it even more interesting because for me in Ukraine there is a functioning judiciary. I would be able to, the first thing I would do would be to send an MLA to Ukraine. Maybe not right now, but this is something I could do. They might need support, there might need to be a link between someone else. That would be an official link acting in between, probably not an NGO that I would go through. But this is for me a very sort of national perspective because I work in a public environment. I need to do that by, within the limits of the law. I can request for information from NGOs, but it's limited with so much because I cannot always share information to get information. So basically my question is how, and it's posed primarily to you, Christian, and to Bill, how would you gain the trust to share information from the NGOs to these public? And I would say that the IIIM and UNITAD are public in that sense. Because also I remember in the beginning with IIIM, I felt that no one wanted to share, but then they were also not empowered to be the central repository, and there was no other option. So I feel that there is it sort of goes both ways. Thank you.
Well, the guidelines or principles, I've forgotten which word we decided in the end, make it clear that you have to share. You can't engage in the criminal investigative space as a private actor and then refuse to share with the public authority. It's inconsistent with your funding, public funding. If you have private funding, okay, fine. But so that's how we're trying to attack that problem. Why Siege is self-contained. It's quite big. It's not trying to own all the space. It's not a mechanism. We're not trying to become a hub for Syria or anywhere else. It's not our mission. Siege collects stuff, shares it. That's it. In other parts of that mission. But we are aware from yourself, Irena, from other colleagues, that they get nothing or almost nothing, or from certain NGOs, Syrian, other situations. I could speculate on why that is. I think there's two reasons. One is that they don't have anything to share, yet their funding is dependent in some degree on having convinced the donor that they're collecting in support of criminal justice accountability. Or worse, they're collecting in support of accountability. Some of this social scientific, again, for the kids at home, I'm looking carefully for the right word, social scientific gobbledygook that's used by the donors, the funding parts of the donors. So I think partly they don't want to be exposed, and then partly I think there's this idea is knowledge is power. So we have something, somebody else wants it. The minute we give it up, we don't have any power. So I think these are the two reasons. But again, as soon as we get those, the guidelines are done. They just need to get them rolled out. And it says you have to share. Yeah.
Could I just follow up directly? Because it's not only the question of, I think a lot of NGOs would share, but it's more the fact that for us, if you look at the Ukraine, someone was saying in a genocide network meeting, we need a list of all the different NGOs. And I don't know, is it expected that we should then ask every single NGO? That's why we're looking for, we need the central repository to be able to function, or to be able to at least in some way say that we did what we could to explore if there was more information. So I'm not saying that these NGOs are not willing to share to national authorities. They might, but it's just that there's so many, and they don't see that we don't have the ability to ask every single one of them for information.
So I'm reasonably familiar with the Ukraine situation that you're talking about. Look, it's a serious mess. You've got Ukrainian authorities in there. They're overwhelmed, obviously, by the scale of the criminality, and they're fighting a high-intensity armed conflict as a state. I haven't seen this in my career. It hasn't happened, frankly, since the war. Second World War, yeah, and with a connection to war crimes issues. There's a very vibrant civil society culture, community in Ukraine, because it is a functioning state, a functioning democracy. And that's also, I've never seen that before in my career. Conflict-affected state with a functioning civil society. Usually there's conflicts in states in part because there's no civil society. So how that's going to be sorted out, I don't know. What I can say with complete confidence is CIGI will not engage in that space because it'll only add to the problem of everyone stepping on each other's toes. But Ambassador Fanchuk is getting this all sorted out. So you may wish to speak to her. It's true.
For our next question, Christian, would you like to add anything on this question and this
It's
comment?
a very interesting question, and I'm thinking about the right answer currently. Because I was thinking about the role of NGOs in the work of UNITAD. We have quite a good contact. We have conferences together with NGOs, but we don't use them as a resource for evidence. So if it comes across, then we would collect that, but mainly we receive evidence through doing interviews by ourselves or gathering documents. well, a lot of them coming from the Iraqi judiciary, by the way, paper documents. You know, ISIL Daesh was an enormously bureaucratic institution producing tons of paper and lists and whatever files, yeah, and of course battlefield evidence like IT equipment, and we have quite a good relation with NGOs, I would say. Well, of course, an NGO typically has a different agenda than an investigative team of the United Nations, so there might be some overlaps, but there might be differences as well. And this is why, occasionally we cooperate with NGOs, even in collecting evidence and sharing evidence, but on the other hand, some NGOs, just are on the victim side and promoting accountability like we do internally in Iraq or somewhere else in the world. This differs quite a lot. You cannot say an NGO is an NGO. Yeah, it's a very broad spectrum. Yeah, I don't know. Maybe even CIJA might be an NGO on one hand, and let's say Yazda on the other hand is or a Free Yazidi Foundation taking care of female Yazidi victims by supplying them with labor, with work, or with food or whatever, social support. Is on the other hand is an NGO as well. So what I wanted to say is that it very much differs, and you always have to get in discussion with the respective NGO if you want to cooperate with them, and if it comes to sharing of evidence. We would not, I think we would not share evidence with NGOs, but the other way around, it happens from time to time.
Thank you. We have another question.
Yeah,
Ambassador
I have a question
Rapp, please.
for Christian, but I would make a comment first. And I certainly agree with Christian. We have a whole range of NGOs, and I interviewed 34 of them for a project last year, and they have different policies on this question. But going even, say, to the press, which isn't an NGO, profit-making companies, generally they're going to assert a privilege, and they're not going to want to share their source information with you. And you have human rights groups that are very involved in advocacy, in writing reports, in helping establish offices like yours, and their position very often is that their information is privileged. I mean, in the Rwanda Tribunal, the great Alison DeForge, who's no longer with us, testified in 11 of our trials, and was almost like an investigative judge in a way, in what she did. But occasionally the defense would say, who was your source for this? And then she'd say, human rights interviewer privilege. And the judges would have to deal with it. But you do have that kind of issue, in part because they can't protect people and because they've guaranteed confidentiality. And even when you deal with a CIJA, and we have shared a substantial amount of the work in the Yazidi investigation with UNITAD and with your predecessor, there's always the question of informed consent and going back and getting consent to the witness to share. And if you didn't get it initially and you can't find the witness, you can have issues with that. You have to follow those sorts of standards. With documents, it's almost always a lot easier unless the rubber stamp of your witness or your source or something appears on the document, and then you've got to work on that question of how that individual is going to be protected and how that might not leak out. So, each of these issues has to be worked out very carefully. The CIJA model, however, is very much to act as if it were before they were created, a mechanism that's going to operate according to the sort of standards of law enforcement and follow chain of custody and have solid rules on how things are done and have the evidence lockers and all of those kinds of things. And then, of course, if you can't get it to public authorities, you've entirely failed in your mission. And so we do have that change. But that was just a comment, but I did want to pose a question to you, and it goes back to right after the passage of the UNITAD resolution. I was in Iraq with a siege mission where we were asked to meet and help train the IHL committee that was going to liaise with UNITAD when it arrived. And at one point we asked them, well, what about digital evidence? Would that be admissible in an Iraqi process? And they said, oh no, we wouldn't take things like that. We want confessions. And I would say, gee, I'd sure prefer to have a document than a confession, which will raise all these coercion issues. But you know, there was this rather traditional attitude about how things were done. And I don't know if in the course of your work it's been possible to get over and to work in modernizing their approach, particularly to your evidence. And of course, the second question, which we haven't talked about, is the very delicate one. The UNITAD resolution took a year to negotiate. In its initial form proposed by the UN Office of Legal Affairs, it specifically prohibited sharing information if it would result in the death penalty. And that was eventually amended to say the issue of sharing would be worked out by the head of this mechanism and the Iraqi committee that would, basically decide these issues. But presumably the issue remains, the policy of a UN agency is not to share with any process that would result in the death penalty. The Iraqi position was always, well, we may not provide the death penalty in this case, but we can't waive it in advance. That would be unconstitutional. So that raised always these very challenging issues about getting information from the Iraqis, processing it, collating it, analyzing it, and then can you hand it back? And if, for instance, like the digital material they have, the phones they've taken from ISIS, if they gave them to you and you did a fantastic report, but in handing it back you might help a death penalty case, you couldn't share it with them. Then why would they share the phone with you in the first place? And I'm just sort of interested that we've always had this challenge in terms of dealing with UNITAD in that it's an investigative mission to help primarily the Iraqi system. And the Iraqi system has this death penalty, which would apply in every single case, to be frank, given the culpability potentially in every single case. It couldn't be excluded. How do you manage this sort of link, this kind of relationship, and build the sort of trust that allows you to get access to their materials, and then find a way to share with them materials that can't be seen to be assisting the application of the death penalty?
Thank you, Stephen. Interesting questions, of course. Both questions I would say relate to each other. It's one of the primary goals of UNITAD to do some capacity building within the Iraqi judiciary. This is what we are currently doing by providing training courses. In future times, I hope, we are just working on it together with the Nuremberg Academy, but we are currently doing that. And this is in order to make the judiciary familiar with evidence-based trials instead of confession-based trials. And in my consultations and discussions with Iraqi judges, the chair of the Supreme Judicial Council, Judge Saidan particularly, and with other investigative judges we are in contact with, I see a lot of openness towards evidence-based trials on international up to international standards. With the participation of witnesses and of victims. This is something what is, getting more and more now, and within the judiciary, and I'm pretty sure that at least in these trials, and this is what we are aiming at, which deal with international crimes cases, not counterterrorism cases, we will see pretty soon evidence-based trials. We're currently working on case building together with the Iraqi judiciary, with investigative judges in the courts, and in order to identify cases which are suitable for these trials as kind of pilot cases. Yeah. This is linked to legislation on international criminal law. As you probably know, there is not such a law in Iraq. There is no legislation in place dealing with international crimes. Well, of course, we are a little bit waiting now. The political situation in Iraq is now, well, they are finding themselves in order to form a new government after the elections in October. Consultations are going on in Iraq, and in our discussion with political leaders and governmental leaders foremost, we identified that having a national legislation on international crimes is one of the priorities. As soon as we have a government again in Iraq, I think we will pretty soon see some intense discussions on a law against crimes, on a law of crimes against international law. Once we have that in place, such a legislation, we can go on with that. And I think sharing of evidence according to the UN politics, which includes that we would avoid to promote death penalties, require a legislation. As I mentioned, we are not mandated to promote accountability in counterterrorism cases, but it's in the mandate to promote accountability for international crimes. It's a difficult thing, of course. We are trying now to cooperate with the Iraqi judiciary where it is possible, and where we can avoid to see the danger of a capital punishment in the end of a trial. This is foremost in financial crimes cases, ISIL financing of international crimes. There, the Iraqi regulations don't require a death penalty in the end. We have other branches where we can cooperate, particularly in capacity building, as I mentioned, or case building. But of course, we will see what will happen in the legislative process regarding a code of crimes against international law. This is a challenge. Of course, I see that. Everybody sees that, and I know that the Iraqi counterparts are well aware of that, and we will see what will happen in the end. I'm convinced that our counterparts know that a lot of, or to a large amount, our cooperation depends on a future legislation, and if, for example, the death penalty is mandatory, it will come to a certain to a very sudden end. Yeah? And but if there are other options of a sentence in the end, it might be easier for us to deliver evidence to the Iraqi counterparts.
Many thanks for that. I think we have maybe time for one last question or remark, if there is any. If that's not the case, I think we have expected to be this panel a bit more light, but I think the whole discussion really draws into many difficult challenges and so on. So I would like to thank all three panelists. Many thanks for your contribution, your intervention, and your honesty in this discussion. And of course, thanks to all of you for posing excellent questions and comments. And with that, I think I'll return back to the organizers.